Imagine standing before the massive, heavy doors of an Indian court. But as you step through, there's an invisible layer surrounding you. Silent data patterns and algorithms, filtering your case before a human judge ever even sees it. Well, this isn't science fiction anymore. Artificial intelligence is officially entering the Indian judicial system. And today, we're going to unpack exactly how. Just think about it. Imagine your court file is processed by AI. Your final judgment is translated by AI, and your lawyer's filing uses AI research. One wrong output, one hallucinated legal citation, or one algorithmic bias could mean devastating delays, financial ruin, privacy breaches, or even the loss of your personal liberty. So who is actually responsible? Is this draft strong enough to protect justice? That's the ultimate question we're answering today. KanoonPlus, promoted by advocate Ravi Kumar, brings you this clear explainer on the Supreme Court of India's draft regulation for how AI may be used in courts and exactly where it draws the red lines. If you follow the courts, the Constitution, criminal law, legal rights, and the rapidly evolving field of AI law, make sure to subscribe to KanoonPlus. So what does this 2026 draft actually do? Honestly, it's fascinating. The Supreme Court isn't trying to just ban AI. Instead, they're laying down an institutional framework to adopt it responsibly. They've anchored the whole thing on some absolutely non-negotiable principles. We're talking human primacy, total transparency, strict accountability, data protection, cybersecurity, privacy, and above all else, judicial independence. The system actually wants the massive efficiency AI brings, but only if these foundational rules are rigorously followed. And that brings us to the absolute core rule of this whole draft. It's simple, but it is profound. AI can assist, but it can never replace judicial authority. The human judge remains entirely responsible. Any output generated by an AI system is strictly advisory. It can never, ever supplant the independent decision of a human officer. To put it simply, AI can help the court, but AI cannot become the court. Okay, so practically speaking, what is this AI actually allowed to do? Well, the draft explicitly permits AI to handle the mundane, heavy lifting stuff to clear up those infamous backlogs. It can do defect scrutiny in new filings, schedule hearings, prepare cause lists, and monitor case backlogs. It's also allowed to do automated transcription of hearings, translate judgments, and provide accessibility tools for litigants with disabilities. It can even help with legal research, citation verification, summarizing documents, and running guided chatbots to help people understand procedural rules. Pretty helpful, right? These tools sound like a real game changer. They promise to make the court significantly faster. But hold on a second. What if the AI doesn't just stick to scheduling? What if it starts quietly evaluating a litigant's credibility? Or what if it secretly profiles an accused person's background based on flawed data? This is where we get into the terrifying possibilities of unchecked algorithms. And this is exactly where the Supreme Court draws some hard red lines. The draft is incredibly strict here. There can be absolutely no AI-only judgments and no AI-only findings of law or fact. There is also a total ban on risk scoring. That means AI cannot be used to assess if someone is a flight risk, predict if they'll reoffend, or decide bail. No way. There is also zero room for opaque black box AI systems affecting a person's liberty. Unauthorized surveillance? Banned. Undisclosed AI evidence? Nope. The draft encourages AI for sure, but it draws a massive red line around liberty and judicial independence. To enforce all these rules, the draft maps out a serious top-down bureaucracy. At the very top is an apex body at the Supreme Court level. Below that, every high court gets its own AI committee, supported by an operational AI secretariat. And before any AI system even touches a courtroom, it has to pass a mandatory ethical impact assessment and go through controlled testing. They're also setting up a formal AI register to document approved systems, an incident database to constantly track errors, an absolute manual fallback protocol in case the tech crashes, and an annual transparency report to keep public trust intact. But, here is where we introduce the real villain of the story. The biggest threat isn't just some rogue algorithm. The real danger may be weak implementation, heavy dependence on private tech vendors, and the potential misuse of incredibly sensitive judicial data. Private companies are the ones who inevitably build and maintain these systems. If we don't control them tightly, the risk of data leaks goes right through the roof. To fight that exact risk, the draft introduces strict contractual safeguards, focusing heavily on what they call sovereign deployment. Simply put, this means highly sensitive court data must stay on-premise and fundamentally secure. Private vendors are strictly prohibited from ever using court data to retrain their own external AI models. The courts retain strict audit rights, demand continuous cybersecurity checks, and mandate that any breaches be reported immediately. The data belongs to the justice system, absolutely not the tech companies. So, stepping back to look at the whole picture, the pros are undeniable. We're talking massive efficiency gains, better access to justice, critical translation tools across India's languages, and effective backlog monitoring. But we have to admit, the draft leaves some critical gaps. For instance, the audits are supposed to be in-house, which raises some serious red flags about audit independence. Plus, do district courts actually have the technical capacity for this right now? What about AI accuracy in complex Indian languages, or unclear grievance timelines? And those cybersecurity vulnerabilities are still looming large. Because of these gaps, we really need some critical improvements before this draft becomes final law. We need to see independent technical reviews and public summaries of these AI audits so citizens actually know the systems are fair. We need ironclad safeguards specifically protecting criminal liberty, sealed matters, and cases involving children. We also desperately need strict multilingual benchmarks, a clear roadmap for the district-level rollout, and mandatory AI literacy training for the judges who are actually going to be relying on these tools. Ultimately, the question is not AI or no AI. The technology is already here, folks. The real question is whether AI can enter our courts without weakening fairness, privacy, accountability, and human judgment. AI को courts में कहाँ तक allow किया जाना चाहिए? कमेंट में अपनी राय लिखिए, वीडियो शेयर कीजिए और ऐसे सीरियस लीगल एक्सप्लेनर्स के लिए कानून प्लस सब्सक्राइब कीजिए.
Follow KanoonPlus for court cases and real legal clarity. Subscribe now and drop your view in the comments.